And thank you for joining me. We're going to be discussing approaching employment, tips for employers on negotiating and contracting this afternoon. For those of you who don't know me, that's me right there. There's a picture. I'm going to give you a little background on our firm before I get moving on today's topic. Our healthcare department specializes in representing practitioners, and we assist in audit defense work with our fabulous private payers in the state, United Healthcare, Aetna, Blue Cross, all of them. Emblem, I'm working on one today. Healthcare compliance, HIPAA compliance is a big one lately. Stark law, anti-kickback, so third-party arrangements. We assist in all different types of review and helping practitioners get into proper arrangements, helping practitioners get out of improper arrangements, healthcare litigation, practice disputes, issues with employees, contractual issues, buy-sells, employment agreements, of course, partnership, things like that. Licensure, you get a letter from OPMC or OPD, certainly we're available to assist. Practice collections and general management representation, we're happy to assist with. So our topic today is for employers. If you missed our seminar last week on employees and contracting tips, that is available on our website, and you can view that at any time at your leisure. And we talk specifically to employees, more specifically to residents and fellows leaving training, and we're offering general basic tips similar on the other side of the coin to what we're going to discuss today, which is tips for employers. So because this is a one-way discussion, unfortunately, with the format of webinars, I will just be giving you my general 2 cents on some standard areas that are relevant to all employment relationships. And hopefully those of you on the call or listening to this, if it's pre-recorded, will find the general tips helpful. We see a lot of employment contracts, drafting them and reviewing them, probably at least 200 or 300 per year. Right now is the thick of it in the contract season with residents and fellows leaving training. And so the advice and the feedback you're going to be getting from me is from across the board, from all specialties of medicine. I see contracts for and I draft contracts for. So any questions you have after, you can feel free to contact me and we can discuss. Okay, so to get started, approaching employment, I think that this is really, most people don't get their lawyers involved until much later, but this is the three considerations that I see when thinking about whether or not to employ, or is it time to hire. How much time do you have available to see your patients? If you're a small practice, or even if you're a bigger practice, is there time to add someone else? Do you have enough availability of space and patient availability for them coming in to treat to add someone? Is the money there? Do you think you're going to be recouping your investment that you're making in another individual? If so, it may be time to bring someone new on board. The SAFE I have representing the considerations that an employer has to the safety of their patient population and protecting what they've been building over the many years. For many of my clients, the thought of bringing in a new practitioner is scary because they're not sure if they have the money or if they will have the money from the patient care, and also are they bringing in someone who will potentially be poaching patients or referral sources from their practice. And it is these considerations that have to be balanced to determine whether or not now is the right time, and of course whether or not you're finding the right fit. So there aren't really hardline rules here. It's more of a what works for you. So it is certainly a decision that my client has to make on their own. I'm here to assist them in their exploration of whether or not now is the time to hire. But these are the considerations. certainly a few of them we can protect from. We can structure compensation, which we'll talk about in a few minutes, in a way that maybe you feel there's less potential for shortfall. We can do that by not guaranteeing an amount or guaranteeing a lesser amount, and possibly structuring a productivity compensation, paying on a percentage of collections, something of the sort. On the concern of poaching, we certainly can protect by incorporating restrictive covenants into the contract that you're going to offer an individual coming to you, whether that's going to be a partnership arrangement or employment. Today we're going to stick to the employment topic for the most part, and we can get to those provisions later about what you can incorporate. But I will say at the start of our talk, because at the start of your conversation with the prospective employee is when you should have this conversation, you want to be upfront about the terms of the employment. And again, we'll talk about compensation later, but that means that you don't want to spring a restrictive covenant on someone, a non-compete, let's say, and the final stages of contract negotiation. So we're going to get to contract terms in our conversation today, but I want to start off by saying that when you're approaching employment and approaching an employee, transparency, I've found, is the best case scenario going in. So you want to kind of have an idea of not only what you're looking for, but what you're willing to offer and what kind of protections you want to have in place with the individual going forward. Many of you have probably already experienced that when you change your mind or change your terms, that's a very easy way to sour negotiations. And this is very different than other scenarios in our life where we are negotiating to get something, a car purchase, let's say. You can have a dealings with an individual you're purchasing from, and then you get to walk away with your car. Sour negotiations with an employee who's going to be coming in and working with you day after day, of course, take on a much more unpleasant tone because you have to live with that bitter taste in your mouth after the fact. So we want to try to be as forthright and transparent going into the relationship as we would like the relationship going forward. So that's just some basic tips on when we're approaching our employment. One of the next steps that's an internal decision for you to make is whether or not the individual you're looking to bring on board is going to be classified as an employee or an independent contractor. Now, the independent contractor classification is very alluring for many employers and also for the employees. This is when the person who's coming in is going to be getting a 1099, responsible for their own taxes, and they can take their own write-offs through their own company. But unfortunately, how you want tax treatment is not the determination as to whether or not someone should be classified as an employee or an independent contractor. There's very specific laws and rules on this topic, and the source that we look towards is the IRS to give us guidance on classification. And I have a slide here that lays out for us our considerations, which is that the general rule is that an individual is an independent contractor if the payer, here the employer, has the right to control or direct only the results of the work and not what will be done and how it will be done. I go on to say on the slide, you are not an independent contractor if you perform services that can be controlled by an employer. This applies even if you are given freedom of action. What matters is that the employer has a legal right to control the details of how the services are performed. So for many of us out there who are looking to employ, we are not going to be giving free range on how services are going to be performed. With medicine and hiring a professional, whether it's a PA or a physician, you could take the approach that the individual is a professional and is working completely autonomously and therefore should be treated as an independent contractor. We see this a lot in the dental realm, actually. With many of our dental clients, they insist on classifying dentists coming out and into their practice as independent contractors. And I can tell you that unless you meet these elements, you are not properly classified as an independent contractor. However, I will say that since this is an IRS tax determination, I personally defer to your accountant, who hopefully works with other medical professionals and has a basis for their determination as to whether or not the independent contractor status is appropriate. There are 3 categories that the IRS specifies when you are looking to classification: behavioral, financial, and type of relationship. This is straight off of the website. So under behavioral, again, we go back to the control issue. Do you have the right to control what the worker does and how the worker does his or her job? So what can we talk about there? Well, are we talking about whether or not we have control over schedule or resources that are available or approach to actual treatment? Well, any of these 3 categories that I just named that falls under behavioral, when, where, how, there may be a spectrum that your employees fall under as to how much you actually exert over them in their performance. So it really is going to be a factor test, and there is, again, no bright line rule, but we do our best to try to figure out where we fall in. Financial, are the business aspects of the worker's job controlled by the payer? Same thing, similar. Are expenses reimbursed? Do we have to oversee what expenses are going to be reimbursed and pre-approved prior? For many of us, we do allow CME to be reimbursed, or possibly other catering or for referral sources, things like that. And whether or not they have actual free range is up to you. But in the most cases, a physician employee or PA would not qualify as independent because they are under your supervision and control in the workplace. So I think we can move on from employee versus independent contractor, but just know that before you categorize someone as an independent contractor, you really want to make sure that you and your accountant feel very comfortable that you are properly listing that individual as such and that they are independent enough to actually qualify. The consequences of treating an employee as an independent contractor is, well, if you come under audit by the IRS, which is certainly never pleasant, you will have, of course, the money you spend having representation to defend you in the audit, and then also you may be responsible for the employment taxes for that worker. So there is a ramification, and it's one that should not be treated lightly. You want to try to make sure that you're classifying appropriately as you bring someone on. One of the biggest concerns, or the biggest concern that your employee is going to have coming on is, how are you going to pay me? How much am I going to be paid? When am I going to be paid? And how is that going to happen? So salary considerations, of course, this is much better to have a two-way conversation for myself with my client to get a better sense on what you're looking to do and how you want to compensate. But the majority of relationships I can give for general topic comments is most specialties are paid with a flat base salary on an annual basis. Certain employers wish to utilize an hourly model. I personally don't have a preference. It's really however you want to calculate. If you're interested in having your employees clock in, clock out, and as soon as they're off the clock, you're off the payments, I could understand hourly. Physician employees are typically exempt employees because they're professionals, so you can pay them a salary. Other employees that you have on staff, administrators, mid-levels, even PAs, and certainly nurses, they are non-exempt, and you are required to pay overtime. And that's New York State law that I'm quoting right now. Different states may have some different rules on it, but for New York State, mid-level providers and administrators are absolutely required to receive overtime and are considered non-exempt. For our physician employees, which is who I'm really trying to focus on today, I do recommend, again, a base salary, which you can do hourly, or you could do a flat annualized amount. That's one option. The second option is you can do a percentage model, incentive compensation, where you're paying a percentage of either gross or net collections. And how we define gross would still probably, in all cases that I use, is taking out any amounts for refunds or repayments that are owed. Net collections, you tell me what you want to carve out. Are you looking to take out any and all overhead associated with this employee prior to getting to the percentage model? Split, which oftentimes, depending on the specialty, the employee normally receives 30, 35, 40, I've seen even upwards of 50%. If it's a special arrangement, possibly the employer you're bringing in is coming with all of his or her own patients and has been practicing a long time and has made a very stellar argument as to why they should be receiving a much higher percentage. That's great, but make sure you do not commit to gross collections, which is total, and then a high percentage without taking into account how much money you are laying out for that individual to be in your space. Are you looking to carve out supplies? Have you properly allocated the amount of money for rent you're paying for the space that they're utilizing? Are you covering their malpractice insurance? All of these considerations have to be taken prior to having that initial discussion where you are making an offer or you are potentially agreeing to compensation terms. The reason why I say that, again, which I'll reiterate probably more than I already have, is if you commit yourself to a position and then you renege on it, that is when we have problems finalizing an arrangement with an employee or in any other negotiation process, really. So you want to make sure to shorten the process, ease the process with a potential employee, that you know what you want to offer, that you clearly communicate with your potential employee exactly what those terms are. Now, sometimes clients wish to capture that in a term sheet that they want to actually present or a letter of intent. Those documents are absolutely fine. We make sure that they read as non-binding. However, if you are not fully ready to commit to terms, I would not recommend putting your suggestions to the employee in writing, number one. And number two, sometimes those documents are duplicative of the actual contracting process. If you take a term sheet or a letter of intent that does not have all of the terms in it for the contract that the contract will have, then you may be putting the cart before the horse, because you'll negotiate the letter of intent and then the contract will have more terms in it that also require negotiation. So you will be creating duplicative effort. So a lot of times I recommend, let's just skip to the contract. Let's present it. Let's get this done. So that way you don't have to spend more time on it and more money for legal on the front end for the LOI and on the back end for the contract. So that's my perspective on the letter of intent and term sheets. Then again, a basic term sheet could be very helpful, sitting down and discussing with the employee what's actually going to be offered. So moving on with compensation, I want to be really clear. Many people focus on that top left box that says salary. That is only one component of how I view, and I would recommend you categorize, compensation. The other major areas is the center box, of course, insurance. Insurance costs a lot of money, which we all know, whether it's a professional malpractice insurance or health insurance or any additionals you may be offering. Those are really the main two for insurance. If you're offering a disability policy, possibly you're offering life. Most places do not offer those things where the employer is actually contributing. I'm not sure if any of us still have a pension plan or captive insurance. These are all things that certain employers do have and certainly can be referenced as part of the compensation package when you're presenting it to an employee. Relocation costs, if you're expecting a physician to move to a new state. Let's say you've interviewed someone coming out of Minnesota from residency and you want them to come and relocate to New Jersey. Typically, relocation costs are in contracts set forth specifically very specifically on how you want it to read. Let's say you're offering $10,000. Well, you may want to condition that $10,000 that the individual has to stay for at least a year. And if they don't stay for the full year, they are required to pay back the amount that has been fronted to them for the relocation cost. You can do that. Same thing with a sign-on bonus. Not many specialties as a general practice offer a sign-on bonus. That doesn't mean it's unheard of. It doesn't mean that it's not negotiated by certain candidates that you're interested in. So same thing with the relocation costs. I recommend that a sign-on bonus be negotiated, and also that the terms be specific, that it's not unconditional. You don't get this, employee, for speaking with me and signing on the dotted line and then reneging on your contract, even though the check has cleared. You would be required to give that back to me if you don't stay for a certain period of time, and that would have to be delineated specifically in the contract. So you want to be careful and make sure that that you have fully hashed what you're willing to expend on an employee, and you've documented it appropriately, and you're protecting yourself on the back end should things not work out. Additional expenses, are you going to be paying for CME? CME, if you are paying for it, everyone wants to know, well, what's the standard? I hear that a lot. Jennifer, what does everyone else do? I want to know what I should be paying out for this. Well, if you're paying $1,500 for CME for a full-time employee, that is acceptable. The more normal number that I see is closer to $3,000 for CME. And normally with vacation and CME, vacation is categorized as a certain amount of days off, and then CME is additional days off. Certainly you can lump them all together for paid time off if you're giving paid time off, which would be relevant if you're giving a base salary, a set annualized amount that the individual is earning. If you're paying on an hourly basis where the person has to be there to work, it's up to you whether or not you want to give paid vacation. Okay? It's up to you if you want to give paid vacation, period. If you're a large employer, you would already know this, but if you qualify for FMLA, you are required to give certain amounts of time off, and that would be if you have 50 employees plus. You're required to give off for family, medical leave, emergencies, pregnancy, things like that, maternity leave, 3 months. If you're a small employer, there's no requirement for you to provide set time off or vacation. If you put that obligation on yourself by establishing a policy or adopting an employee handbook, possibly one that was sent to you from your payroll company, you didn't bother reading it, and you let everyone sign it. Well, if that's the case, then you may be in trouble, because policies may be in that handbook that you are not interested in actually abiding by, but once it's written, so shall it be done. So you have to be really careful and make sure you understand what your policies are, and make sure you're not treating similarly situated employees differently. I wouldn't bring on one employee and offer them 5 days, same position, same type, and then offer the next one 10. You want to make sure that you have uniform policies for the practice, and your employees will certainly thank you for it. Additional benefits, I have that in here, but we kind of already named a number of them, whether or not you're offering some sort of retirement plan, insurance, are you offering health insurance for families, what kind of deductions are you taking from that out of employee salary. These things should be presented up front, so that way there's no surprises when the employee comes on to fill out any intake forms you have for the onboarding, and everything should be up front. That's what I would recommend. Of course, as the physician employer, who you may be listening now, you have an HR person, possibly an office manager, who can handle a lot of the details with the individual who's joining you. And of course, that's completely appropriate and what you should be doing. Hopefully, you're not handling all of the T crossing and I dotting, otherwise you wouldn't have time to see patients. Moving on from compensation, and of course, I'm not getting into specifics for compensation because everyone's arrangements are different. So if you have a specific question on how you're structuring comp, I am happy to address with you offline. Term and termination. This is a big one. normally employment contracts run for at least a year, and they automatically renew. If you want to have a set term, so that way you force yourself to come back to the negotiating table, you can do as you like. If you'd like a 3-year contract, 5-year contract, you can put whatever term you want in, and if the employee is amenable to signing that, then there you go, you have a term. Now, of course, the term is somewhat irrelevant with the next concept if you are allowing for termination. Now, one of the biggest considerations that many of us face with termination is we are now no longer in the at-will category, which at-will, for those of us who don't know, is a concept where you can fire anyone at any time for any reason, effective immediately, if they are at will, so long as that reason is not a discriminatory reason. If you're not firing for race or sex, gender, religion, if you're firing because you don't like how the person dresses when they come to work, that's okay. We just can't fire someone because they are too old for patients to see them at the office. So termination, I say that this is more important than the term because even if you have a 10-year contract with someone, if you have the ability to terminate them at any time for any reason because they're at will, then you really don't have a contract with the term. Similarly, because most of our professional employees are not at-will employees, we have a 30-day or 60-day or 90-day or sometimes 180-day without cause termination provision in our contract. They would no longer be at will. You would have to provide them notice for termination. And if the without cause says 60 days, then you have to provide them 60 days notice. And unless the contract states otherwise, you're required to pay them any set salary that you've negotiated with them for the full notice period, the full 60 days. We have oftentimes put into contracts, which can be seen as a little draconian, but I recommend it if having coverage is a big issue for you, that if an employee has an option to terminate without cause, and they do so upon inadequate notice, let's say it's a 60-day notice period, they give you 60 days notice, hey, sorry, Steve, I got another job, I'm leaving, but I can't give you 60 days because I have to start my new job next week, so I'm giving you 5 days notice. We've put in before a liquidated damages provision to prevent employees from doing that, and that provision would state that for every day of failure to give proper notice, the employee owes the practice a set amount of money, whether it's $500 a day, $1,000 a day, to recoup your cost and effort to have to find someone very quickly as a result of the inadequate notice. And that provision is upheld as challenged, assuming that's drafted correctly. And it's something that you may want to consider to make sure that employees are incentivized to give you adequate notice in case they are actually going to be departing from your practice. Additional to termination, the basic generic without cause we've already gone over. There are reasons to fire someone for cause. If they are no longer useful to you because something has happened that you can't have them seeing patients, of course they have to go. So what am I talking about? Well, they've had a licensure proceeding or negative disciplinary determination rendered against them. They've been thrown out of Medicare. They've been thrown out of Medicaid. They've been thrown out of a hospital. Privileges have been revoked. Third-party payers will no longer let them participate on a panel. All of these reasons will make it harder for you potentially to do business depending on your practice model. And they all are sufficient to qualify for cause termination, assuming that you've listed them in there. Sometimes we don't want such a long contract where we list all of this stuff out. So we could also say for cause that if you fail to adhere to the requirements in the contract, or if there's a material breach of the contract, that qualifies as cause as well. Because there will be other areas in your contract that you're giving out to the potential employee, assuming you're working with an attorney, that the employee has to abide by. For instance, the representations and warranties section. which I recommend that you have in there. You're going to be asking this person who's coming on to represent to you that they are appropriately licensed in any state that you're going to have them practice on behalf of your medical practice. You're going to make sure that they're representing that they have the ability to write prescriptions unrestricted, that they participate in certain payers, or you're going to agree to credential them or have them get credentialed before they come on board. These are all things that we want in the contract for representation. We'll also want to make sure that they have not been party to a lawsuit or not currently party to a lawsuit for malpractice. And you may also want to inquire about moral turpitude. You want to make sure that they haven't been arrested previously, they have a clean record. All of these areas are ones of concern, and a lot of this due diligence should be done before you've extended an offer. You can ask employees to sign off on a background check, and our firm handles background checks, or you can work possibly with your payroll company. They may be able to do it for you. Maybe you want to know if the individual you're hiring has incurred substantial debt, or if they were arrested at any point in their life. These are things that may be relevant to you in your hiring decision. If you fail to conduct at the proper time, it may be too late, or you'll probably just forget and move on, which is fine, assuming that things work out. But if you have reason to be concerned, or just as a general course of business, you want to incorporate these practices into your medical practice, certainly it's not a bad idea to have a little bit of due diligence performed on someone who's going to be joining you. I can tell you this. The employees are doing their homework. Before they come in for the interview, at least you would hope, they're researching the practice, definitely Googling all of the partners, and trying to figure out if this is the right fit. So for you, you should try to differentiate between the candidates who are coming in. If you're just looking to hire right out of school, their academic accomplishments, professional accomplishments are going to look pretty similar. So you may want to make sure that you're conducting a little bit of an extra background check, so that way if there is something massive differentiating this one individual from the rest, you feel comfortable knowing that it's not an arrest. It might be something hopefully positive. So for termination, we want to make sure we have adequate lead time for someone departing. I've had requests that we put in contracts that individuals cannot leave without cause during certain times of the year, because for certain specialties, the hiring is cyclical, and there's several months where there's just no one available for replacement, or so like clients have felt, and we've put that into the contract. It's really, parties can agree to anything that's not illegal, essentially, or non-compliant. So you have a lot of free range on what you can negotiate and get into with your employees. So it's really just how you want to move forward. So protections post-term, I spoke about a lot of this. Notice, we talked about with or without cause. Compensation limits. We want to make sure that it's specific, that the individual will only be entitled to receive the money that has accrued already but not been paid. We do not want to give, by accident, with poor drafting, a right to severance to an employee that it was not intended to have that right. So you have to be really careful on the termination language and what money actually is due and owing to the individual who's leaving. Confidentiality is a very big deal, of course, because we are all obligated by HIPAA with our patient information. So we want to make sure that upon leaving a practice, let's say we are hiring a radiologist who possibly has some equipment at home, maybe they do home reads. We want to make sure that everything is turned over back to the practice. Any hardware that you've issued to one of your employees has to be returned. That goes, by the way, for every level of employee. And you also, just a separate tip outside of employment or employment contracting issues, for any admin staff that you have, or physician, or any staff at all that have been issued hardware, you want to make sure you keep an updated list on who has what and whether or not it's been returned. And you also should have a policy in place on how they should be treating that hardware while it's in their possession. This is a major concern with all of the increased activity under HIPAA protection. Any kind of loss of hardware or data could potentially be tantamount to a breach, and result in tremendous exposure for the practice. So it's very, very important that we're careful with our HIPAA information. Patient record protection, again, this comes into play in a lot of different areas, but post-termination, anything in an employee's control, remote access into the system or actual physical records that may be in their possession should be returned. Employee representation, we went through already. Is the individual licensed? Are you requiring board certification? If they're not eligible, if they're board eligible but haven't taken it yet, do you want to limit how many times they can take the exam or require them to take it within a certain period of time? If board certification is important to you and your practice and your patients, or possibly for participation on certain insurance panels that you participate in, you may want to put that up front. Certain of these concepts you may want incorporated and require prior to the employee starting with the practice. And that's fine. You just want to be really clear about what is a condition precedent to the contract term beginning. And that's something that we would put directly into the agreement, and you want to be upfront about with the individual when you are finalizing terms. Non-compete and non-solicitation provisions. These fall under our restrictive covenant section and are very important. Certain employers are going crazy with restrictive covenants now, and they are having employees sign a 10-mile radius on a non-compete from any and every location of the employer. Some of those employers are major hospitals, and they have locations everywhere. They've included in the definition any affiliates, any successors, any assigns, any subsidiaries. So literally, they could be encompassing hundreds of square miles of coverage that if an individual were to sign that, they would have in place a contract prohibiting them from working. Now, a contract is a piece of paper that can be torn up and thrown out if need be. The tear up and throw out procedure, unfortunately, is requiring appearance before a judge of competent jurisdiction to render that contract or its provision null and void, or to limit its application and to grant permission to an individual to work within, let's say, a restricted range. That can be very expensive. It can also be expensive for the employer on the alternate side enforcing the restriction, which is where we would be. So what I recommend is you include this on your list of terms, not to be snuck by or stuck into the contract last minute, but to be presented, negotiated, and agreed upon at the start of the discussion. Now, the non-compete element, which is the range where the employee can work during the term of the agreement potentially and for a time thereafter, that provision is less important to me and for having a large range than the next concept, which is often overlooked, the non-solicit. The non-solicit for the employer, I think, is the whole meat and potatoes of the restrictive covenants. We do not want our employees to be able to come in, work for us, build a rapport, meet our patients, and then leave with patient lists contacting our patients and taking them elsewhere. It's the contact that's the issue. So for me, the non-solicit is much more important than, say, having in a 25-mile radius for a non-compete. If we're in downstate and we have a practice located in Queens, New York, if we have a 5-mile restrictive covenant for a non-compete radius, that is a lot of land. That you're really going to have to drive a little bit to get out of that range. So if you're operating on Queens Boulevard and you have a 5-mile radius in any direction, I doubt many of your patients are actually going to travel outside of that range to go see an associate that was working with you. And if they are, God bless them. That's fine. 5 miles is a lot of range, but 25 miles is certainly going to be excessive unless you are of a specialty that is so specialized, so specific, that a court will see that there's no one else who could have treated these people, and the employee who left is actually a threat to your practice and to your ability to earn your livelihood, which is the test that the judge is going to employ if this were to be challenged. So from my perspective as the employer, you really want a very, very tight non-solicitation provision where there's no direct, or you could try even to say there's no indirect contact with the patients. That one's going to be tough to uphold. So as long as the patients aren't leaving your practice to go somewhere else because they've been directly solicited or indirectly, maybe you want to prohibit an employee from being able to utilize a Facebook account to contact patients, things like that, LinkedIn. Those types of relationships are what could lead to patients defecting. I think that you're pretty safe. So for the non-compete, we want to be somewhat reasonable in the range. Maybe we limit it to where the individual is actually spending the majority of their time providing services. And then we make sure that the non-solicitation is very, very carefully crafted. In addition to the actual provisions that we just went over, the next step is the remedies. What language do I need to be able to enforce the non-compete and non-solicit? Well, actually, that's a very specific answer, and it's the language that you need to be able to enforce is going to be more important than the actual restriction. You need to be able to stop the conduct that is in violation. So you need the ability to be able to bring an action for an injunction. You do not want to have to post a bond, and you're going to want to have a blue pencil clause in your contract which says that if any portion of a restriction is deemed to be unreasonable, then the court of competent jurisdiction that deems it unreasonable has the authority to lessen the restriction to a reasonable range. And these provisions, again, I'm sure you can see why, are just as important or more important than the actual restriction because this is the teeth behind the bark. So it's important for us to make sure that this section is very carefully crafted. And that's why you really should be working with a healthcare attorney, so that way you know that the language is done correctly. How can we hire anybody if we don't have the right to collect for their services rendered? Well, the answer is you can't. So the billing and collection language that's supposed to be in your employment contract, or should be in your employment contract, will allow your practice to properly credential or contract for an employee. So if you're a participating provider and you participate with Aetna and Emblem and United, and all of your patients are in network, it's necessary that you have the ability to get your employee on these plans. And you're going to want to get your employee on these plans before they start. So you want to get the credentialing process done well in advance, which is why, unfortunately, you have to hire before you have the need. Otherwise, you are operating with the need and you don't have the hire available to do the work. So for many of us, that's a tough decision, and we often wait too long. We bring someone on possibly too early before we can get them paid, or we bring them on too early before we actually have the work. But these are the breaks, and we all work it out. You can ask for a power of attorney, a limited power of attorney is what I would recommend, for the individual to sign off and allow you, authorize you and your staff to be able to get done what you need to for the billing and collection. This language has to be drafted very specifically. It will require notarization. You should have a notary signifying that they actually were presented with a limited power of attorney and they watched the signature of it for it to be effective. That's often a requirement in all states. But you can have your local state check if you're not in New York. So power of attorney, we recommend that. That'll give you the ability to get done what you need to be paid. Audit coverage for billing and collection. What do I mean by that? Well, it's pretty simple, and it's language you're going to want in your contract. If you're hit with a third-party payer audit for money back, a potential overpayment request, let's say from United, because your new employee has been upcoding or is not properly documenting their services. You're going to want the ability to take the money that you're paying back on their behalf from them. How do we do that? That has to be done contractually. If you do not have that language in your contract, you will not have any standing to be able to have the employee reimburse the practice or pay directly for exposure that they've created. This is not a fun concept. It's not one that I recommend that you bring up during discussions. It's one that I recommend that you have included in the agreement, and the employee will see it when they have the opportunity to review the potential contract. And if they're smart, they'll have their own lawyer look at the agreement, and it's language that can be discussed, but not language that I would recommend be removed given the vast amount of oversight and audits. If you want to be reasonable about it, though, if your practice and maybe possibly practice employees are the ones that are performing the coding services and the billing actual process, which is always the case, obviously. The physician is never actually doing the billing themselves, possibly the coding, though. You may be willing to be reasonable and accept responsibility for any exposure that is caused by the practice through its billing practices. The medical documentation, that side of it should be left to the employee, and they should be held responsible for that end. But if it's a procedure issue on how the bills are being submitted, that I would recommend you leave to yourself to take responsibility and possibly to indemnify the employee for. So that'll bring us into indemnification, which is a sticky legal concept, but one that needs to be employed into each of your agreements, really most of your agreements that you're ever going to have with anybody else. It basically says that I'm going to take responsibility for this exposure and pay for it. And it allows you to shift the burden of payments, essentially, is really what it's going to come down to, for certain scenarios. So the example that I just gave with the billing, where the practice will be responsible for any problems with the process, while the employee will be responsible for any problems with the documentation, the indemnification provision would read, I, employee, agree to indemnify and hold harmless the practice from any and all claims, costs, expenses, fees, etc., incurred as a result of any documentation issues related to my medical services. And then you could add on, except that the practice will take responsibility from any exposure due to the billing and coding process, if the practice is doing the billing and coding. So what that does, what that statement that I just made says, is that exactly that. The employee will take financial responsibility for the medical documentation errors that result in any overpayment request, and the practice will take responsibility for any coding or process issues. Now, what kind of process issues could I be talking about? Well, let's say you've accidentally been submitting 2 of every bill, so duplicative billing, okay? Or we're adding the wrong modifier on after the physician is done with their work. You have people doing coding for the doctor. These are issues that come up all the time and that lead to exposure and monetary demands, and we want to make sure that the right party is taking responsibility for their exposure. So this is contract language that you absolutely want included. The final concept that I wanted to talk about in the actual contracting issue today, because we have one more topic that I'm going to go over, is extending partnership. When is the right time to talk about it? When's the right time to do it? Well, I would say only about 2 to 5% of the time in the employment agreements that I review. For those of us who are joining late, I already said in the beginning of the call that I look at probably 200 to 300 contracts a year because we do a lot of reviews for residents and fellows along with the employer agreements that we put together. And I would say that only 2 to 5% talk about partnership, which I like. I don't like to see partnership mentioned in an employment contract, especially if it's someone who you're not sure about and you don't really think you're going to want to stay on or possibly extend that offer to. The reason is that you don't want to agree for terms later on. That's always a bad idea. So if I'm pressed by a client to say, no, I promised this person that they would have an opportunity to be considered. The language that I like to put in is extremely non-committal, and we'll talk about how in a couple of years we'll think about possibly maybe extending you an offer. And I leave it at that. I don't put in the terms of the potential offer. The financial circumstances of the practice may change. The ownership structure of the practice may change before the partnership offer is extended. Now, a question that I can anticipate from the audience is, but Jennifer, what if we already know we are extending and this person's being brought on for, let's say, 3 months and then partnership's going to be done while we drop the contracts? Well, then let's just say it that way. Today's talk is on employment contracts specifically. I didn't include, which I didn't think we'd have time for, which we don't, since I promised I'd keep this under an hour. I don't think that we could do another talk on the partnership contract specifically, but I don't think that the employment agreement is the proper forum. It's not for presenting partnership terms. Partnership requires financial review. Accountants should be involved. It's more than just the basic concepts of employment. You're bringing someone on into an ownership structure where there should be an operating agreement in place if you're a company, or a shareholder agreement in place. We have to talk about the buy-in, the buy-out. There's additional terms. So extending partnership, how do you do it with an employee you're bringing on? Well, I would just say that you're willing to consider them. I wouldn't extend definitive language as we talked about. If you have a particular circumstance that you want to discuss that is more definitive than that, then again, I still wouldn't put the terms in the employment agreement. I would discuss presenting an employment agreement for a certain period of time, and then I would put the proper partnership documents together simultaneously with the employment contract. I know that sounds duplicative, but many partners have an employment agreement in place along with the partnership documents, whether or not that's joined to the operating agreement or a buy-in agreement for the shareholders. So that's what I would do with partnership. Okay, terminating the wrong fit. I thought I would just give a couple of tips on terminating the wrong fit before we wrap up today. And one of the best things I could tell you to do is before you commit to a long-term contract, especially if you're bringing someone on who you don't have any referrals for, or hasn't been recommended, you don't really know them, it's a brand new person, you really don't know if they're going to work out for the first 1 to 3 months, possibly even 6. So I like to put in a probation period for this individual where you would be able to terminate at any time for any reason, as long as it's not discriminatory. So essentially treating them as an at-will employee for a period of time before your notice period kicks in for such termination. So a lot of times I'll do this for the first 90 days. You could extend it for 6 months if you wanted to, or a year, or you could do for initial 90 days, and then you could say that, you know, at your discretion it could be extended. What this does is it loosens your hands to be able to actually get rid of someone who's not working out. If you miss this period, but you have someone who, let's say you have a hospital-based practice, or not based practice, but you have a practice where you're required to go to the hospital and round, and so you have this individual coming on. They're not really watching them that often, but you start getting some negative feedback from the hospital. And I've had this scenario come up a number of times where I get a call from a client who says, Jennifer, we have this contract. You put it together for us. We had this probation period in there, actually, but I really didn't know how bad he was, how bad this employee was, until really kind of the 4th, 5th month. I started to get a lot of complaints from the hospital that this individual is providing services at on my behalf, and I have to get rid of him. How do I do it? And at that point, to get rid of that person immediately, in these contracts, sometimes there's a 90-day without cause or 120-day without cause. We have to be able to terminate for cause. And terminating for cause, while we have all these reasons in the contract, what constitutes cause, it still has to be documented appropriately, and the termination has to be done in a certain way that it shows that the activity actually was tantamount to cause. So you're really tying your hands and creating a little bit more of a problem for yourself documentation-wise when you're not inside of that probation period. So I do recommend that you do consider carving out a period of time when you can terminate for any reason or no reason at all, and to actually be cognizant of that time frame. If you need to contractually extend it, do it. If you need to terminate during that period, do not put it off. Do not wait till you get back from vacation. Do not leave a note for your office manager that this has to be done at a later point in time. Make sure it's done during the probation period, because if you elongate it, you are going to have a more difficult time, and you may have to be calling me with an employment issue that you could have avoided if we took care of it earlier. If you do need assistance terminating, you want to talk about whether or not you have proper documentation, you're interested in possibly offering a severance in exchange for a release, those are all things that you should be working with an attorney for. Please do not DIY, do it yourself. This area is a very sticky one, termination, and leads to a lot of aggravation if there is a claim made by an employee for inappropriate termination for not proper cause, or if it doesn't want it done the right way. So just be really careful when you're looking to terminate the wrong fit, and any advice on that I'm happy to give. Of course, it would have to be offline for a specific circumstance. So that brings us to the end of our Lunch and Learn series, which we're kind of doing. This is our second one in 2 weeks, and we have another talk next week, which will be geared predominantly towards dental, mainly dental residents. We're happy for you to join us for that, but it may not be applicable. If you have any questions or concerns on this topic for contracting, you can feel free to contact me. For all listserv members, I do not charge you for a phone consult with an initial question or concern. If you keep calling me with the same question or concern and thinking that it's an initial consult, well, I'm sorry, it probably will not be treated as such. But to call me for a first time with a question on contracting, I'm happy to discuss with you, and then we'll decide together whether or not you need further assistance. Sometimes you don't, and sometimes you do. So feel free to contact me, and I hope this was helpful. If you have any other topics that you'd like us to do a presentation on, please feel free to email me. And if you are not on the listserv already, you can go to our website and sign up right on the front page. We do twice a week, every Tuesday and Thursday usually. We mail out to about 3,000 providers. Most of them are New York doctors. Many of them are outside of that range, anywhere from California to Hawaii. We have a couple of doctors from Mexico on there. We're happy to take questions and answer anonymously, as you'll see. Anything that comes up, feel free to write in. Okay, wishing everyone a good week, and thank you for joining us. Bye-bye.